We're now going to look at Fisher, Chapter 6, after World War II, and we're going to look at a couple of cases that are important and you should familiarize yourself with. I'll give you some background. I'm going to read actually from parts of the decision. So the first one is CNS Airlines versus Waterman Corporation. And here, a ruling frequently cited to uphold broad presidential power in external affairs is from Justice Jackson in 1948. The Supreme Court analyzed a statutory provision that authorized judicial review of orders issued by the Civil Aeronautics Board, including those that grant or deny applications by citizen carriers to engage in overseas and foreign transportation. Those orders were subject to the President's approval, and writing for a 5-4 court, Jackson acknowledged that Congress has constitutional authority over foreign commerce and may delegate large grants to the President, but he then argued that the President also possesses in his own certain powers conferred by the Constitution on him as Commander-in-Chief. All right, so that's the fundamental of the case. That's what we're looking at, and I want to go over that now. I want to read excerpts from it and then elaborate on it. So, and I'll do the same for the North case. Also, another important case that you should get your minds around. You can find these cases, look them up online, or in constitutional law books. Probably easiest to look them up online. All right, so I'll lay it out first as the court laid it out. The question of law which brings this controversy here is whether subsection 1006 of the Civil Aeronautics Act authorizing judicial review of described orders of civil aeronautics boards includes those which grant or deny applications by citizen carriers to engage in overseas and foreign air transportation, which are subject to approval by the President under subsection 801 of Act 49 U.S.C. Subsection 601. All right, so we'll get into the particulars here. Congress has set up a comprehensive scheme for regulation of common carriers by air. Okay, many statutory provisions apply indifferently whether the carrier is a foreign air carrier or a citizen carrier, and whether the carriage involved an interstate air commerce, overseas air commerce, or foreign air commerce, each being appropriately defined in another part of the U.S. Code. All air carriers by similar procedures must obtain from the board certificates of convenience and necessity by showing a public interest in establishing of the route and the applicant's ability to serve it. Well, when a foreign carrier asks for any permit or a citizen carrier applies for a certificate to engage in any overseas or foreign transportation, a copy of the application must be transmitted to the President before hearing, and any decision either to grant or deny must be submitted to the President before publication and is unconditionally subject to the President's approval. All right, so what we've got here is something pretty straightforward. You've got the President of the United States. If you want to engage in this, you have to have the President of the United States, and that really means the executive branch, look at it and approve it. All right, so that gives the President of the United States a lot of power over commerce, and in the Constitution, it's pretty clear that commerce is under the control of and in the power of the Congress. Okay. The other question is judicial review. Does the court get to review these actions? So there are two issues here. One, the President's ability to approve these particular rights, or can the court even hear this case? So those are two of the important issues. What's going to come out of this is, what we're interested in is whether or not this particular case grants further power to the President, or there's a misreading by the court, as Fisher would see it, and they grant power that should not be granted to the President of the United States. Okay, so it says here, this court long has held, from the decision, this court long has held that statutes which employ broad terms to confer power of judicial review are not always to be read literally. Where Congress has authorized review of any order or used other equally inclusive terms, courts have declined the opportunity to magnify their jurisdiction. By self-denying constructions which do not subject to judicial control orders, which from their nature, from the context of the act, or from the relation of judicial power to the subject matter, are inappropriate for review. So the court has laid out for itself what the boundaries are, right, for the kinds of cases they will look at, right? And what they're saying here is that from the nature of the case, again, this is not defined, but from the nature of the case, right, or from the context of the act itself, or from the relation of judicial power to subject matter. In other words, does the judicial authority extend to the particular subject at hand? Or is it outside their purview? Do they not even have the right to hear it? So there are certain boundaries put in place, whether or not the court can review. So that's the first issue the court's coming up with. And they're going to have to sort of justify, whether or not they have the right to even look at this. Again, they've laid out those particular lines, right? So what they're saying is that, look, if we've got a situation where the context of the act, the thing that's in the act, is not something that they can look at, it clearly resides in one of the other branches, then there's no judicial review of it. All right, so here's the background. The Waterman Steamship Corporation, urges that review of the problems involved in establishing foreign air routes are of no more international delicacy or strategic importance than those involved in routes of water carriage. Now, what they're trying to do is they're trying to associate the rules governing shipping with that of air transport. That they feel they both have, one's on sea, one's obviously in the air, right, flying, but basically they're performing the same function. All right? It says, quote, "It is submitted that there is no basic difference between the conduct of the foreign commerce of the United States by air or by sea. From this premise, it reasons that we should interpret this statute to follow the pattern of judicial review adopted in relation to orders affecting foreign commerce by rail." So we got foreign commerce by rail, we got it by sea, we got it by air. And they list a couple of cases that are important or germane. And the function of the Aeronautics Board, which is involved in this, obviously, by the name of the case, in respect to overseas and foreign air transportation, that the Maritime Commission to such commerce, when waterborne, right, we find no indication that the Congress either entertained or fostered the narrow concept that airborne commerce is a mere outgrowth or overgrowth of surface-bound transport. No indication that Congress either entertained or fostered this narrow concept that airborne commerce is just the same as surface-bound or water-bound commerce. All right, but these resemblances must not blind us to the fact that legally, as well as literally, air commerce, whether at home or abroad, soared into a different realm than that had gone before. Okay, makes sense, right? Air travel and all that. Ancient doctrines of private ownership of the air as pertinent to land titles had to be revised to make aviation practically serviceable to our society. It was a lot easier with shipping. And over land, you could say what belonged to what particular nation, or there were boundaries so you could understand it. Now you're flying over all of this, so airspace has not been necessarily well defined here. Okay, a way of travel which quickly escapes the bounds of local regulative competence called for more penetrating, uniform, and exclusive regulation by the nation than had been thought appropriate for the more easily controlled commerce of the past. In other words, this is all new. Things are flying, and the way in which we looked at, goods moving across land or over the sea was pretty well set up in terms of where boundaries were, national boundaries and the like, even in terms of the sea. So it was pretty easy, and they put in place rules and all that. But now something new had happened. Now we've got air travel. And air travel is not bound in the same way that shipping or land transport is, in that obviously you're going over, as I said, nations, and It's all about the airspace at this point, right? While transport by land and by sea began before any existing government was established, and the respective customs and practices matured into bodies of carrier law, independently of legislation, air transport burst suddenly upon modern governments, offering new advantages, demanding new rights, and carrying new threats, which society could meet with timely adjustments only by prompt invocation of legislative authority. So all I'm saying is this. Even before there were governments, before we came up with rules about transporting across the sea or over land, those things by custom had already developed. People had been doing it a long time, and over that period of time, there were in place certain rules which developed, expanded, altered, and the like. So when we came to that, when the court came to that, or any country came to that, there was already set into place by custom the way in which we deal, or are going to deal, with things that move across land or across the sea. So it was a slow process that took place over a long period of time that was worked out through custom over that period of time. And what they're saying now is that air transport happened very quickly. And no one could have foreseen the issue of air rights, or what does that mean? Because nothing was put in place because the technology was so new. There was nothing that was comparable to it. So the argument that, well, it should be the same as it is for land and for sea, it should be the same for air, they're pointing out at this point in the decision, well, it's really not the same, because there's two things. One, there's been no time, to really have custom sort of kick in and do this slowly, right? So that it would be adjusted and reformed based upon the needs and the differences that developed. There was a basis for all of this, and it took a long time to put that in place. But here, this came on the scene relatively quickly. No one understood what to do with it, and so there was no benefit of, the past to the present. All right. However, useful parallels with older forms of transit may be in adjudicating private rights. We see no reason why the efforts of the Congress to foster and regulate development of a revolutionary commerce, air flight, right, that operates in three dimensions, should be judicially circumscribed with analogies taken over from two-dimensional transport, two-dimensional over land, over sea, and air, obviously, travel adds that extra dimension, right? Altitude. Okay, the public interest that enters into awards of routes for aerial carriers, because that's the issue here, right? Who gets to use what routes and transport goods and so on, who in effect obtain also a sponsorship by our government in foreign ventures, is not confined to adequacy of transport service, as we have held when that term is applied to railroads, and they give a couple of cases here. That aerial navigation routes and bases should be prudently correlated with facilities and plans for our own national defense. So they're bringing national defense into this. Remember that over land and by sea took a long time. If you declared war on another nation across the ocean, it could take months to get there. Now with air transport, it's a lot quicker. So this national defense issue comes up and raise new problems in context of foreign relations is a fact of common knowledge. Everybody knows this is problematic. From a defense point of view, from a commerce point of view, everyone kind of knows it's an issue. So there's a problem here. Congressional hearings and debates extending over several sessions and departmental studies of many years show that the legislative and administrative processes have proceeded in full recognition of these facts. Why is this important? What they're saying here is that, there's been work done on this. And those that have worked on it are very clear that these things about national defense and foreign relations have been at the forefront. They've been very aware of those things, and they've been at the forefront of their discussions. So what the court's trying to do here is say, so we have work that's already been done. And it appears that the work that's been done has been informed by this idea of, national security, as well as by, debates extending to commerce and that sort of thing. All right. In the regulation of commercial aeronautics, the statute confers on the board many powers conventional in other carrier regulations under the congressional commerce power. Okay, the commerce power is very expansive. Today, it's incredibly expansive. It covers basically everything. It's the most important and most powerful tool that Congress has. Because under, and if this was common law, we'd go into it more, but under the commerce, Congress can pretty much do anything. Almost everything has some sort of direct or indirect impact on commerce, or is connected to commerce in some way in which is inescapable by its nature. They are exercised through usual procedures and apply settled standards with only customary administrative finality. Congress evidently thought of the administrative function in terms used by this court of another of its agencies in exercising interstate commerce power. Such a body cannot in any proper sense be characterized as an arm or an eye of the executive. Stop. There have been administrative agencies put together by Congress in areas of commercial conduct and so on in the past. And there's no way that you can say that Congress did that, and in any way the executive branch has some sort of power that grows out of this or is related to it. This is what Fisher referred to when I first read, that it seems to be moving in one direction, right? The president doesn't have that authority, and now it's going to move perhaps in another direction, right? Okay. But when a foreign carrier seeks to engage in public carriage over the territory or waters of this country, or any carrier seeks to sponsorship of this government to engage in overseas or foreign air transportation, Congress has completely inverted the usual administrative process. Instead of acting independently of executive control, the agency is then subordinated to it. Instead of its orders serving as a final disposition of the application, its force is exhausted when it serves as a recommendation to the president. Congress has passed this along. The president now has more or less final say, right? Instead of being handed down to the parties as the conclusion of the administrative process, it must be submitted to the president before publication even can take place. Have Congress now ceded some of its power to the president, rather than the administrative agency that makes the decision and then Congress acts on that. Had they given the president authority now, Congress. Nor is the president's control of the ultimate decision a mere right of veto. The president has a right to veto. They're not giving him that. They're giving him the authority to make the decision, right? It is not alone issuance of such authorizations that are subject to his approval, but denial, transfer, amendment, cancellation, or suspension as well. He's not just saying yes or no. He can deny it, he can transfer, he can amend it. President is doing a lot of what Congress would do, okay? Thus, presidential control is not limited to a negative, but is positive and detailed control over the board's decisions, unparalleled in the history of American administrative bodies. You got an administrative body, right? That administrative body is going to do what? That administrative body is going to make decisions. They're going to look at the instances. They're going to make particulars. They're going to make a decision in that instance, a recommendation. Congress acts. That's the way it works. That's the way it's always worked. But now, Congress, the president's got this power to basically, be the one that makes all of these decisions. Now, you can see why this is an important case. If we say the president has this sort of authority, that's an incredible expansion of presidential power. Okay, Congress may, of course, delegate very large of grants of its power over foreign commerce to the president. So they have the right to do this, and they cite some cases. The president also possesses in his own right certain powers conferred by the Constitution as commander-in-chief and as the nation's organ in foreign affairs. You can see where there's an intersection here, right? Commander-in-chief, if you're going to say national security, obviously against foreign nations, is what we're talking about, then the president as commander-in-chief has that right. And so this, in some measure, falls under that. Also, the president represents and speaks with that one voice, as we've said, for the entire country in foreign affairs. Well, is in commerce part of that? So Congress has delegated to the president even more power in those areas than one might interpret from the Constitution. Okay, So the argument here is, well, there is some a nexus here that you have to consider because the president does have some power, right? On basically the commander-in-chief and the sole organ of foreign affairs, constitutionally. For present purposes, the order draws vitality from either or both sources. Okay. Legislative and executive powers are pooled, obviously to the end that commercial, strategic, and diplomatic interests of the country may be coordinated and advanced. In other words, no one, Congress nor the president has all the power, but rather it's coordinated power. In other words, they have to coordinate, make consistent commerce and national security, and so they have to work together in order to resolve these issues because each has a piece of it. President is commander-in-chief and sole organ of foreign affairs, and Congress because they have control over commerce. Okay. These considerations seem controlling on the question whether the board's actions on overseas foreign air transportation applications by citizens are subject to revision or overthrow by the courts. Now we're back to the courts. We know Congress has a piece of it. We know the president has a piece of it. And we haven't really addressed exactly where those lines are drawn, but we know that they each have a piece of it. Now the question is, what about the courts? It may be conceded that a literal reading of subsection 1006 subjects the reader to re-examination by the courts. It also appears that the language was deliberately employed by Congress, although nothing indicates that Congress foresaw or intended the consequences ascribed to it by the decision of the court below. The letter of the text might with equal consistency be construed to require any one of three things. Okay, this is the actual language that has been put into place. First, judicial review of a decision by the president. Second, judicial review of a board, aeronautics board, order before it acquires finality through presidential action. The court's decision on review being a binding limitation on the president's action. And third, a judicial review before action by the president, the latter being at liberty wholly to disregard the court's judgment. Okay, we think none of these results is required by usual canons of construction. They're going to look at it in a different way. In this case, a submission of the board's decision was made to the president, who disapproved certain portions of it and advised the board of the changes which he required. The board complied and submitted a revised order and opinion which the president approved. Only then were they made public, and that which was made public and which is before us is only the final order and opinion containing the president's amendments and bearing his approval. Only at that stage was review sought, and the president had done this, review by the court. And only then could it be pursued, for then only was the decision consummated, announced, and available to the parties. All right, so the president made a decision. Now you can look at the decision. While the changes amended at direct of the president may be identified, the reasons, therefore, are not disclosed beyond the statement that, quote, because of certain factors relating to our broad national welfare and other matters for which the chief executive has special responsibility, going back to commander-in-chief or going back to sole organ, right? He has reached conclusions which require changes in the board's opinion. So my job is to do this. I don't like what the board's doing. Change this. The court below considered, the lower court, and we think quite rightly, that it could not review such provisions of the order as resulted from presidential direction. The president, both as commander-in-chief and as the nation's organ for foreign affairs, has available intelligence services whose reports neither are or ought to be published to the world. It would be intolerable that courts without the relevant information should review and perhaps nullify actions of the executive taken on information properly held secret. So basically what we're saying here is that, the president has access to information that's really important in making these decisions. And so maybe the president has even a greater role to play here because they're privy to information that the general public and even generally Congress is not necessarily aware of. Nor can courts sit in camera, right, in order to be taken into executive confidences. In other words, you can't, the president's not going to say to the court, come here, let me explain to you what's going on, let me give you the state secrets. That's not going to happen. But even if courts could require full disclosure, the very nature of executive decisions as to foreign policy is political, not judicial. And that's a key difference. The court deals with those things which are judicial in nature, not those things which are political in nature. If there is a political, consequence of something, then maybe if there's a constitutional component of it, yes, but not a policy that's just political in nature. Okay? Such decisions are wholly confided in our Constitution to the political departments of the government, that's the executive and, of course, the legislative branches. They are delicate, complex, and involve large elements of prophecy. They have to more or less predict things and figure things out. They are and should be undertaken only by those directly responsible to the people whose welfare they advance or imperil. Not the court, but the people should look at those policies because they're political in nature, and they're the ones that are affected by it. They are decisions of a kind for which the judiciary has neither aptitude, facility, nor responsibility, and have long been held to belong in the domain of political power, not subject to judicial intrusion or inquiry, right? They don't entertain, the court does not, political questions. They do not deal with policy in that way. And they cite several cases. We therefore agree that whatever of this order emanates from the president is not susceptible of review by the judicial department. The court below thought that this disability could be overcome by regarding the board as a regulatory agent of Congress to pass on such matters as the fitness, willingness, and ability of the applicant, and that the board's own determination of these matters is subject to review. The court, speaking of the board's action, said, quote, "It is not final till the board and the court have completed their functions. Thereafter, the completed action must be approved by the president of citizen air carriers in cases under Section 801. The legal incongruity of interposing judicial review between the action by the board and that by the president are as great as the practical disadvantages." Okay? Getting involved has benefit, but it also has consequences. The latter arise chiefly from the inevitable delay and obstruction in the midst of the administrative proceedings. They're injecting themselves into this. And again, the president's ability to act decisively and quickly is of value here. The former arises from the fact that until the president acts, there is no final administrative determination to review. The statute would hardly have forbidden publication before submission if it had contemplated interposition of the courts at this intermediate stage. In other words, something has to happen first. The court can't interject itself before something happens. Nothing happens till the president makes the decision, and then at that point, one can look at it. Nor could it have expected the courts to stay the president's hand after submission while they deliberate on the in-court determination. Can interfere with presidential's act, right? I don't mean like law, I mean acting. The difficulty is manifest in this case. Review could not be sought until the order was made available. And at that time, it had ceased to be merely the board's tentative decision and had become one finalized by presidential discretion. All right, so you're with me? So now we're at the point where the court is looking at this and saying, okay, the board did something, the president approved it, the board then went ahead and executed. Until the decision of the board has presidential approval, it grants no privilege and denies no right to any air carrier or anyone. It can give nothing and can take nothing away from the applicant or a competitor. The board can't. It may be a step which, if erroneous, will mature into a prejudicial result, as an order fixing valuations in a rate proceeding may foreshow and compel a prejudicial rate order. But administrative orders are not reviewable unless and until they impose an obligation, not reviewable by the court, deny a right, or fix some legal relationship as a consummation of the administrative process. Court can interject itself. So they're making that point again. The dilemma faced by those who demand judicial review of the board's order is that before presidential approval, it is not a final determination, even if the board's ultimate action, and after presidential approval, the whole order, both in what is approved without change, as well as in amendments which he directs, derives its vitality from the exercise of unreviewable presidential discretion. So back it up, because you have to understand that they're piecing this together. There's been no action taken, so there's nothing to review. It's like the court interjecting itself into legislation before it's voted on and before it's decided and they know the impact of it. They're already looking at it. The court, does not do that, right? The case is not ripe yet. Nothing's happened. We need a consequence, not a process. In other words, if you've got a process, the court will not interject itself. But once the process is complete and there is an impact, right, based on that process, then the court has something against which to thrust, its responsibilities. So the court is not interested in looking at anything until an action is taken place. Not the process. The administrative board has to do its job, give it to the president. The president says, hey, this is fine or it's not fine, and then they can act on it. Once that process is complete, then the courts can impose itself, right? To revise or review an administrative action which has only the force of a recommendation to the president, it's nothing more than that, would be to render an advisory opinion, which the court never does, in its most obnoxious form. Advice the president has not asked, tendered at the demand of a private litigant on a subject concededly within the president's exclusive ultimate control. Okay. Advisory opinions, meaning the court does not look at something. Presidents and legislative bodies can't go to the court and say, if we do this, what do you think? Is it constitutional or not? That's an advisory. We're advising you. No, you do your job. And then if there's an issue that comes out of that is reviewable, then we'll look at it. And then our decision will be instructive for future endeavors that are similar in nature, future legislation, right? This court early and wisely determined that it would not give advisory opinions even when asked by the chief executive, president. It has also been the firm and unvarying practice of constitutional courts to render no judgments not binding and conclusive on the parties, and none that are subject to later review or alteration by administrative action. You don't get involved, right? Again, it's got to be after the fact once something has happened. We conclude that orders of the board as to certificate for overseas or foreign air transportation are not mature, not ripe, and are therefore not susceptible to judicial review at any time before they are finalized by presidential approval. So they can find the president approving these things in this process problematic, but nothing's happened yet. After such approval has been given, the final orders embody presidential discretion as to political matters beyond the competence of the courts to adjudicate. This makes it unnecessary to examine the other questions raised. The petition of the Waterman Steamship Corporation should be dismissed, and then the judgment is reversed. But there is a concurring and dissenting opinion that comes from Justice Douglas and Black and Reed and Rutledge, which bears a little bit of touching on. All right. Couple of things. Congress has specifically provided for judicial review of orders of the Civil Aeronautics Board of the kind involved in this case. That review can be had without intruding on the executive domain of the chief executive. And by granting it, we give effect to the interests of both Congress and the chief executive in this field. The Commerce Clause of the Constitution grants Congress control over interstate and foreign commerce. That's Article 1, Section 8. The present act is an exercise of that power. That's their argument. Congress created the board and defined its functions. It specified the standards which the board is to apply, granting certificates for overseas and foreign transportation. Right, you need a certificate to do it. It expressly made subject to judicial review orders of the board granting or denying certificates to citizens, and withheld judicial review where the applicants are not citizens. If this were all, there would be no question. But Congress did not leave that matter entirely to the board. Recognized the important role the president plays in military and foreign affairs, it made him a participant in the process. Congress did. Applications for certificates of the type involved here are transmitted to him before hearing. All decisions on the applications are submitted to him before their publication, and the orders are subject to his approval. Since his decisions in these matters are of a character which involve an exercise of his discretion in foreign affairs or military matters, I do not think Congress intended them to be subject to judicial review. Sole organ of foreign affairs and commander-in-chief. Okay, I don't need to go any further with that case. It's important for a couple of reasons. One, the idea of Congress taking some of its power and saying to the president, you have the right to do this, when the president also has arguably power of their own under the Constitution in terms of commander-in-chief and sole organ of foreign affairs. There is a nexus, there's an interconnection between what Congress has to do here under commerce and what the president has to do as sole organ and national security. So it makes sense that these would join and that they would work out a way in which all the necessary parts would be satisfied: commerce, foreign affairs, and military and national security. The court says we don't belong in this argument. Okay? And so, in this sense, Congress, in doing something like this, would necessarily give more power to the president. The question is granting that power necessary? Is it necessary for affecting commerce? In terms of making it happen, in some way improving it. You get Congress setting up administrative agencies, and those agencies usually report to Congress. But there are agencies under the executive branch as well. So what the courts are trying to say here is that this has got to be worked out in a way that each branch meets its responsibility, but is sensitive to and works with the other in coming up with a policy or a means of execution that are suitable for the goals and the intent of both the executive branch and Congress. Fisher has issues with this, right? Nevertheless, the court decision here sort of backs off a bit and says, for several reasons, we really can't engage in this. And they point out the power the president has in Congress and says this really needs to be worked out between them. My point is that here you get an expansion of presidential power based on the interpretation. And it would seem reasonable and rational that that would be the case. Nevertheless, it's not something that Fisher agrees with. Believes that there should be a somewhat different interpretation of that granting of the power and allowing the president to be the final arbiter in such matters. So I just want to read one thing from Okay, this is from Fisher, directing his attention to what we've just reviewed in this court decision. The Constitution does not confide all of foreign affairs to the executive branch. Jackson could cite nothing in the Constitution to defend his argument. He described foreign policy as delicate, complex, involving large elements of prophecy. The same could be said about judicial decisions and congressional policy over foreign trade, agriculture, the economy, housing, taxation, and other matters. Jackson urged that such questions, quote, should be undertaken only by those directly responsible to the people whose welfare they advance or imperil. We read that, right? Under that theory, how could he exclude Congress? What happens if executive officials imperil legal and individual rights? As has often been the case, under such circumstance, there must be recourse to the judiciary. That there's a role, at a bare minimum of oversight. I hate to use that word, that's really more of a congressional term. Oversight of these actions. That's Fisher's main complaint. I don't think it's a strong argument, but I do think it's an important one. And that is, where the courts jump in should be where there's an execution of authority. But Fisher kind of extends that more or less to things of a domestic nature, which may bleed over into international affairs, but there is a difference. All right, the other case I want to go through is North versus, it's about deportation. I'll read you the background quick. The Supreme Court deferred an executive judgment about deporting Ella North. Born in Germany of Jewish parents, she managed to escape to England, where she worked during World War II. After the war, she returned to Germany and married Kurt North, a U.S. citizen and veteran who had been honorably discharged. Intent on becoming a U.S. citizen, she booked a ship to America and arrived in New York Harbor on August 14, 1948. Instead of being permitted to land and meet her husband's family, she was taken to Ellis Island. On October 6th, an immigration official recommended that she be permanently excluded from America. There was no hearing. Remember, this is someone who wants to be an American citizen, married to an American citizen. The official justified exclusion because her admission would be, quote, prejudicial, close quote, to the United States. No other reasons were given, and on that same day, Attorney General Tom Clark entered a final order for exclusion. Okay. After obtaining legal assistance, North filed a habeas petition with the district court. The court dismissed the petition, as did the Second Circuit. Neither court objected to basing her exclusion on confidential information withheld from her attorney and federal judges. Now think about that. It's prejudicial. They get rid of it. No one knows why. And the court doesn't get to see why, because they say that it is problematic. The Second Circuit was willing to defer wholly to unsupported and uncorroborated executive claims. Yeah, this is an agency of the president, right? This is what we've decided, and we can't tell you about it. Lacking information as to why she was being excluded, the courts had no basis to judge whether the administration's action was reasonable. On January 16, 1950, the Supreme Court decided 4-3 in favor of the Truman administration. Now think about this. The courts backed out of the way because the executive branch said, we can't tell you about this stuff, but trust us. There's a reason why we're not allowing her in, but we can't go into it. So how do you mount an argument? How do you take your case to court? And then the court accepts that. In a powerful dissent, Justice Jackson found no evidence that Congress had authorized, quote, an abrupt and brutal exclusion of the wife of an American citizen without a hearing, close quote. In other words, wife of an American citizen, there's due process involved here. He said the administration told the judiciary, quote, that not even a court can find out why the girl is excluded, close quote. To Jackson, the claim that evidence of guilt must be a secret and aberrant evidence of guilt, open quote, must be secret and aberrant to free men because it provides a cloak for the malevolent, the misinformed, the meddlesome, and the corrupt to play the role of informer undetected and uncorrected, close quote. That's precisely what it is. That's exactly what it is. He added, open quote, security is like a liberty that many are the crimes committed in its name, close quote. You got to tell us what's going on. You can't just say you got to trust us. We know we can't share it with you because for obvious reasons, the executive branch could do anything, claiming executive privilege, claiming a national security, and fundamentally get away with all kinds of corruption. Okay, so I want to read just a little bit from the court decision, give you a sense of it here. The alien wife of a citizen who had served honorably in the armed forces of the United States during World War II sought admission to the United States on the basis of confidential information, the disclosure of which in his judgment would endanger the public security. The Attorney General denied a hearing, found that her admission would be prejudicial to the interests of the United States, and ordered her excluded. Held. This action was authorized by the Act of June 21, 1941, and the proclamations and regulations issued thereunder, notwithstanding the War Brides Act of December 28, 1945. First, A, the admission of aliens to this country is not a right, but a privilege which is granted only upon such terms as the United States prescribes. B, the Act of June 21, 1941 did not unconstitutionally delegate legislative power to prescribe the conditions under which aliens should be excluded. So Congress never laid that out. Right? All right, so we don't know why. It is not within the province of any court, unless expressly authorized by law, to review the determination of the political branch of government to exclude a given alien. They have their reasons. That's their job, right? It's a political process. D, Any procedure authorized by Congress for the exclusion of aliens is due process, so far as an alien denied entry is concerned. Important. Any procedure authorized by Congress for the exclusion of aliens is due process. That's all you get. No court appearance, nothing. You get your process when Congress decides how this is going to be handled. E, the regulations governing the entry of aliens into the United States during the national prohibition against retroactive operations of regulation affecting her status. Don't worry about that. H, the national emergency proclaimed May 27, 1941 has not been terminated. There you go, crisis. A state of war still exists, and the Act of June 21st and the proclamations and regulations thereunder are still in force. There's a crisis. It's a national emergency, and it's not been terminated. I, a different result is not required by the War Brides Act, which waives some of the usual requirements for the admission of certain alien spouses only if they are, quote, otherwise admissible under the immigration laws, close quote, written by Congress, right? So here you've got a case where under a crisis, the president's power expands exponentially, right? And that's really important. These two cases show the expansive nature of presidential power and how it comes about. One based on crisis, one based on the ability to review presidential actions, especially in an area where there's no real precedent. Okay, but the next case, which is the Steele seizure case, is an exception, because the Steele seizure case is where the court does intervene. Because President Truman, really for political reasons, couching it in terms of the importance to war efforts and so on, the steel mills are on strike, and he says, "No, we need this steel, so I'm going to take over those steel operations. I'm going to seize them so that these workers can continue to work." The court sees through this and says, "No, it's not warranted. This is obviously more political in nature than it is based on any kind of commander-in-chief or sole organ justification." So here's just a bit of it. Background. To avert a nationwide strike of steelworkers that he believed, right, would jeopardize the national defense, President Truman, on April 8, 1952, issued an executive order directing the Secretary of Commerce to seize and operate most of the steel industry of the country. The order cited no specific statutory authorization, but invoked generally the powers vested in the President by the Constitution and laws of the United States. The Secretary issued the appropriate orders to steel executives. The President promptly reported his action to Congress, conceding Congress's power to supersede his order, but Congress did not do so, either then or a few days later when the President sent up a special message. The steel companies sued, obviously. A federal district court enjoined the seizure, and the Supreme Court brought the case up prior to decision by the Court of Appeals. They just pulled it up and said, "You don't decide, just give it to us." 6-3, the court affirmed the district court order, each member of the majority, however, contributing an individual opinion, as well as joining in some degree the opinion of the court by Justice Black. The holding and the multiple opinions represent a setback for the utterance of inherent executive powers. We talked about that before, inherent powers. But they raise difficult conceptual and practical problems with regard to presidential powers. All right, so I just want to read this one more part here. Let's see here, where is it? Where'd it go? Okay. No. Okay. Oh, I'm sorry, there it is. Okay. This is just as we go through the final sort of, putting it together here. It follows that in ways short of making laws or disobeying them, the executive may be under a grave constitutional duty to act for the national protection in situations not covered by acts of Congress, and in which even it may not be said that his action is a direct expression of any particular one of the independent powers which are granted to him specifically by the Constitution. Instances wherein the President has felt and fulfilled such a duty have not been rare in our history. though being for the public benefit and approved by all, his acts have seldom been challenged in the courts. Okay? In this case, they are. There appears to be no sort of underlying justification for the seizure, right? And so the president's power is somewhat constrained here, right? So what we have here is a limitation being placed on the president by the court, right? One more thing. The pivotal proposition of the opinion of the court is that inasmuch as Congress could have directed the seizure of the steel mills, the president had no power to do so without prior congressional authorization. To this reasoning, not only the dissenters, but Justice Clark, in a concurring opinion, would not concur. And in fact, they stated baldly that the reasoning was contradicted by precedent, both judicial and presidential and congressional practice. One of the earliest pronouncements on presidential power in this area was that of Chief Marshal in Little versus Bareem, right? There, a United States vessel under orders from the president had seized the United States merchant ship bound from a French port, allegedly carrying contraband material. Congress had, however, provided for seizure only of such vessels bound to France ports. The Chief Justice wrote, "It is by, quote, it is by no means clear that the President of the United States, whose high duty it is to take care that the laws be faithfully executed, and who is Commander-in-Chief of the armies and the navies of the United States, might not, without any special authority for that purpose, in the then existing state of things, have empowered the officers commanding the armed vessels of the United States to seize and send into port for adjudication American vessels which were forfeited by being engaged in this illicit commerce. But when it is observed that an act of Congress gives a special authority to seize on the high seas and limits that authority to the seizure of vessels bound or sailing to a French port, the legislature seems to have prescribed that the manner in which this law shall be carried into execution was to exclude a seizure of any vessel not bound, right, to a French port." All right. You should familiarize yourself with these three cases. They're important. You'll see stuff on them on the exam, and so you would need to focus on this. All right. That wraps up Chapter 6 for Fisher. Again, Fisher agrees, by the way, with the steel seizure case, to a great extent. Okay, that ends the lecture.